So much, sir. I just want to start off by saying what an honor it is to be here, presenting to all of you, to have been invited to speak at this prestigious conference. And I'm happy to have a little bit of time before lunch. I know the coveted pre-lunch slot to talk about domestic terrorism, one of the most important threats that's facing our nation at this time. And so give you my brief Air Force overview slide. This is what we're going to talk about in the next half hour or so. And I have to give my mandatory disclaimer. The views expressed in this presentation are my own and do not necessarily reflect the official policy or position of the United States Air Force Academy, the Air Force, the Department of Defense, or the United States government. And so with the formalities out of the way, why are we talking about domestic terrorism? Right, I think this is a photo that we're all familiar with. Right, January 6th, a couple of years ago, it has been labeled by many as an act of domestic terrorism. And we'll talk about the definition of terrorism because I think it's an inflammatory word and a word that can be weaponized and used to attack certain people with certain positions and certain beliefs. And so I think it's very important that when we're talking about this subject that we ground ourselves in legal definitions and try to be as impartial as we can with a fairly, as I said, inflammatory word and something that's thrown around. January 6th, we have more than 1,200 folks who were charged with various offenses. None of those offenses have the word terrorism in them. Right, most of the offenses are trespassing in a restricted federal building, or carrying a weapon into a federal building, destruction of government property, theft of government property, but nowhere do we see the word terrorism. But it's one of the most important threats, the biggest threats facing our nation, according to the Department of Homeland Security. You can see on this chart that we have increasing incidents of domestic terrorism by year. And it's just a huge problem that we need to get our heads around and that we need to start addressing in a more systematic way within our law enforcement capabilities, right? As General Dunlap said, as a military JAG, as a military attorney, I do not handle domestic terrorism cases, right? This is something that the military is not really a part of the primary defense structure. But we do have a definition of terrorism, right? I said at the beginning that we need to plant ourselves in these legal definitions to make sure that we are applying them in as neutral as possible, in a way that's as neutral as possible. And so we have a definition, 18 U.S.C. 2331.5, that talks about when something crosses that threshold from a belief into a problematic act. So we have acts that are dangerous to human life that appear to be intended to either intimidate or coerce the civilian population, to influence the policy of government, or to affect the conduct of government. And it has to occur primarily within the territorial jurisdiction of the United States. Our foreign terrorism definition looks almost exactly like this, except you can imagine C is different. It occurs primarily outside the territorial jurisdiction of the United States. And again, this is a definition. This is not a criminal statute. We do not have a criminal statute through which we can prosecute folks who are accused of committing domestic terrorism. And so because this is still domestic terrorism, is something that we are still we're grappling with. We're still trying to get our understanding of this threat. I'm going to spend a couple minutes talking about how we have tackled international terrorism, because this is something that we have dealt with on an escalated level for longer than we've been trying to grapple with the domestic terrorism question. So I'm going to touch on some of the mechanisms and authorities that we use to prosecute international terrorists. So we're going to talk about the FTO designation, the SDGT designation, as well as executive authority to regulate foreign affairs. So when we're talking about foreign terrorist organizations, right, we have legislative authority for this designation that comes from the Immigration and Nationality Act and from the Foreign Relations Authorization Act. Right, this is a designation that has several requirements, right? It has to be made by the Secretary of State in consultation with the Attorney General and the Secretary of Treasury. The terrorist group has to be foreign. It must be a foreign organization that has the capability and the intent to engage in terrorism, and it has to threaten the security of U.S. nationals or United States national defense. And Congress has to be notified. They have 7 days to object to this designation, and if there's no objection, the designation is published and takes effect. And there are some pretty severe consequences that we see for foreign terrorist organization designations, including prohibition of material support or resources. So groups cannot donate to foreign terrorist organizations. If they do, it is a federal criminal charge, a felony that they will be charged with. There are immigration ramifications for members of foreign terrorist organizations, and the Treasury can freeze these organizations' assets. We're talking about SDGTs. This is a requirement, this is a designation that can be imposed by the Secretaries of State and Treasury. Right? They have to consult with each other. They also consult with the Attorney General and the Secretary of Homeland Security. The requirements here, you can see them up on the slide, they're more broad than an FTO designation. Right? And because it's broader, right, more organizations can fall under this umbrella, there are lesser consequences, right? There are no immigration consequences, but these organizations and assets can still be blocked. There are criminal penalties, but they're lower than with a foreign terrorist organization, right? So we see in the context of foreign terrorism, these group designations are very important for us to prosecute and fight the threat presented by foreign terrorist organizations. And we'll touch on executive authority in foreign affairs. For those of you who are comic book fans, I put up Thanos' Infinity Gauntlet, right, to show how much deference courts historically give the executive branch when it comes to foreign affairs. Right, there are a couple court cases up there, Curtis v. Wright and Holder v. Humanitarian Law Project, which essentially say the executive, the president, is the sole organ, the sole voice of our nation in foreign affairs. Very, very broad deference, lots of power given to the president and the executive branch when it comes to operating in foreign affairs. Holder v. Humanitarian Law Project was essentially a case where we had a nonprofit organization that was donating resources and supplies to an organization that had been designated as a foreign terrorist organization. Right? And they claimed, this nonprofit claimed that their First Amendment rights, freedom of speech, freedom of association, were being violated because they were unable to donate and support this foreign terrorist organization. They specifically were interested in preserving the culture and language of one of these groups. Right? They had no intent of furthering the illegal use of force that this organization was partaking in. However, the court said government interest trumps yours, nonprofit. Right? Government interest in protecting this nation, in national security, trumps your interest in donating to this group. They said your right of association, your freedom of association, is not being violated. You can still associate with them, you just can't give them any money. Right? And so we see the extreme deference given to the executive to protect our nation and to protect our national defense. But where does that deference end? It ends in the United States, which is what makes domestic terrorist organizations such a difficult question, right? Because Holder, that case we were just talking about, specifically said this would probably look different if we were talking about a domestic organization, right? Because deference to the executive in foreign affairs goes away when we're not talking about a foreign organization. It goes away when we're not talking about foreign lands. Okay? And so we have more protections for our domestic organizations, and we have to start talking about and considering those constitutional issues when we're talking about domestic terrorist organizations. And so some of our most cherished liberties, freedom of speech, freedom of association, have greater protections here in the United States. And so when we're talking about freedom of speech, right, First Amendment, Congress shall make no law abridging the freedom of speech. There are two categories of speech, though. There's protected speech, which is subject to that protections in the those protections in the Constitution, and we have unprotected speech, Think things like child pornography. That is unprotected speech, right? We also have true threat and incitement are categories of unprotected speech that the government can regulate, right? This is why it is criminal to threaten harm against somebody. That is speech. You have not taken any actions yet. But if it's a true threat, meaning there was a subjective, the speaker intended the speech to be threatening, it was perceived as being threatening, taking into account the context of the speech, right? There are times when we criminalize speech for very good reasons, right? And so when we're talking again in the context of domestic terrorism, we need to keep these categories of unprotected speech in mind, because this is the only way, this is the only place where the government can regulate speech without violating First Amendment rights. Okay, with incitement, we touched on true threat, but with incitement, speech has to produce imminent lawless action or be likely to produce such action, right? And we get that test from the Brandenburg case. In freedom of association, we have some very strong civil rights era cases, right? And NAACP versus Alabama and the Claiborne hardware case both talk about how you cannot, the government cannot make it illegal to be a member of an organization that has both legal and illegal aims, right? NAACP boycott of merchants in the South during that time, right? We saw the NAACP use both legal and force to try to protest for fairer conditions, right, in the South. And so the issue in Claiborne was that they were trying to ban membership in the NAACP because they had pursued illegal means, use of force, to achieve their objectives, right? But the court said, no, you cannot outlaw membership in this group because they do have legal aims. They do have objectives of economic and social change, right? And that we can't make that illegal, right? And so under Claiborne, a group's aims must be entirely illegal and an individual must hold a specific intent to further those aims in order for membership in that group to be made unconstitutional. Right? And so when we're talking about how we can fight domestic terrorism while protecting constitutional rights, there are a few options that a lot of people often talk about, right? And the first one is passing a domestic terrorist organization legislation, prohibiting membership in these groups, right? And as we just talked about, Claiborne pretty much makes that impossible, right? It would be such a narrow aperture. We could only make it illegal to be a member of a group that had clearly declared illegal aims, and the members were furthering those illegal objectives. It's not a viable solution. It would not help us broadly deter domestic terrorist actions from occurring. Some people also talk about the potential of having a post-offense registry, similar to how we have a sex offender registry. However, we run into similar issues, right? Not every member of some of these groups, right? So we had Rise Above Movement, RAM, who traveled for the Unite the Right rally, okay, in Charlottesville. Not every member of RAM was there. Not every member supported the use of force that happened that day, right? And so if you have individual convictions that result in group registration, you run into the same problems because not all members of these groups support these illegal objectives. Right? And we've also experimented with the Smith Act, right, making it illegal to be a member of the Communist Party, right? Back this was passed in 1940. Okay? And so we have the Scales and Noto cases, which essentially struck down the membership prohibition in the Smith Act, echoing what happened in Claiborne, right? We can't make it illegal for someone who who's fighting for social and economic change. We don't want to make membership in those groups illegal, right? So how can we fight this threat if designating domestic terrorist organizations is not a viable option under the constitutional protections? Right? We could designate additional foreign terrorist organizations, right, which would allow us to charge individuals domestically as homegrown violent extremists, right? And so we could designate, like I said, like Combat 18 is a British neo-Nazi group founded in London in the UK, right? And so that is a foreign group. It engages in terrorist activity. They publicly advocate for and perpetrate violence against minority populations. Do they threaten the security of the United States, right? Those are the three factors that we went through before for a foreign terrorist organization designation. Combat 18 has been banned by Canada and Germany in certain, they can't be prison guards, they can't be law enforcement, right? That organizational membership has been prohibited in other countries, right? And so expanding our foreign terrorist organization designations would allow us to expand our homegrown violent extremist prosecutions. We have practical difficulties with adding these FTOs, right? We saw the Russian imperial movement was recently designated as an SDGT, and that took a whole lot of political capital and political will to get a white supremacist group onto the SDGT list. And so we have some practical difficulties with adding these FTOs to our list and just thus expanding our ability to prosecute homegrown violent extremists. We could do a copycat of an FBI gang designation, right? FBI has published a report on gangs for years, and it's been an effective tool for law enforcement to go forth and deter gang activity, right? So legally, the FBI can make this gang list because of the Administrative Procedures Act and the requirement that any agency action has to be final in order for it to basically give legal consequences, right? So if there's final agency action that has associated legal consequences for individuals, then that agency is responsible, right, and constitutionally responsible for what it is promulgating. However, a gang designation is not final agency action because there are no legal consequences associated with it, right? Courts have said they're just producing a report. The FBI isn't actually taking any actions against these individuals. So it's not final agency action. It's not unconstitutional, right? And so we could have essentially either use the gang designation to fight domestic terrorists. That presents its own problems because most domestic terrorist organizations won't qualify as gangs because their goal is advancing an ideology, not preserving power or gathering economic reputation or economic interests. Or we could make a national terrorist organization intelligence center like the National Gang Intelligence Center. Congress just needs to require a report from the FBI. That's a simple legislative fix. Congress needs to require an annual report from the FBI, resource the FBI to engage in this, and we can have similar domestic terrorist deterrence that we've seen be very effective in the FBI's gang deterrence. Right. Expand use of existing federal statutes, right? RICO is difficult with domestic terrorists because we often see lone wolf perpetrators who only commit one offense. And with RICO, you typically have, you need repeated incidents in order for us to use that statute. We have 18 USC 2332B, which allows us to prosecute conduct transcending national boundaries. Again, this is difficult because our lone wolf perpetrators usually are accessing manifestos online. Is accessing a website transnational activity? I think that's a hard argument to make, but we also see folks who actually travel for training. And again, going back to the Russian imperial movement, they host training camps, and sometimes folks from the United States travel abroad, and they go to those training camps. That helps us link it to transnational conduct, which then allows us to prosecute that conduct transcending national boundaries, resulting in death, kidnapping, or assault of anyone in the United States. Right, we also have, this is one that's not talked about very often, but every single state in the United States has laws against unauthorized paramilitary groups. And often our most dangerous domestic terrorist groups are the ones that are arming themselves and conducting these paramilitary activities. Every single state criminalizes this. The Second Amendment, there's precedent by the Supreme Court, Presser v. Illinois, that says while the Second Amendment protects your right to bear arms, it does not sanction private paramilitary groups. Right? That is the prerogative of the government to create a military, not individuals. Right? So we have seen these laws successfully applied in Texas and North Carolina. But there's not a lot of precedent outside of that, right? So lack of experience in this area is a big barrier. There's the concern that we might have some safe harbor states, right? If this is enforced unevenly in the different states, we might see groups migrating to states that don't enforce versus states that do. We also have the potential of escalation, right? Once there's an existential threat against these groups, they might be more inclined to use their arms to protect themselves and to protect their very existence. Right? And these are some of the potential, I know I'm running out of time, I want to save time for questions. These are some of the potential solutions, some ways that we can put together a defense against this domestic terrorist threat. Not any one of them is going to be the ultimate solution. But if we start putting these pieces together, use different legal mechanisms that we have to both defend ourselves against this threat and protect our constitutional rights, we'll be in a much better position to fight this growing threat against our nation. So I'll open it up for questions. Most of what I just talked about is available in an article that's published through Rutgers School of Law. And so if you're interested in hearing more of those details or reading a little bit more about some of these solutions, that's available for you online.
Melissa, thank you very much. Do we have any questions from the audience? Yeah, David?
I can just speak from here. In terms of these state laws against paramilitary organizations, do you think that the federal government can play a role in prodding states to act or cooperating with law enforcement? Because it feels like a lot of focus on domestic terrorism has really been at DOJ, and I'm wondering if they might be able to galvanize some state action.
I think that's a good question, and that's an obstacle that's just inherent in how our system is structured. And I think the way that the federal government might be able to better get involved is through that FBI designation that we were talking about, right? And so if the federal government provided more information and gave state authorities a better ability to prosecute these individuals, I think that would probably be a more feasible way for the federal government to help encourage and enable states to better fight this threat.
Yes, ma'am. Why don't you announce who you are?
My name is Maisie Reddy. I'm an undergrad student at the University of North Carolina at Chapel Hill. Okay. So I'm on enemy turf right now, but I'm having a good time. But my question is, how does the political aspect, specifically different administrations, help or hurt the fight to get better recognition for these domestic terrorist groups?
Yeah, I think a lot of the problem isn't necessarily the different political persuasions of whoever is in power. I think part of the problem is it's just harder to mobilize the U.S. population as a whole against a lot of these ideologies, right? When we're talking about foreign terrorists, right, after the 9/11 attack, that we were all on board, right, with making sure that we were protecting ourselves from that foreign threat. But when you're talking about domestic terrorist organizations, it's usually ideologies that a significant portion of the population supports, or in some way, I think it's, 20% of Americans, I think it is, are against abortion in any form, right? But very, very, very small percentage of that 20% would actually take violent actions, right? And so it's harder to get that consent, regardless of the political persuasion of where that ideology is usually found or who's in power. It's just harder to get us all mobilized and behind some of these, making these ideas, we can't make ideas illegal, right? And so it's just harder to get the necessary force behind and the impetus needed to fight the threat. I'm not sure if that answered your question, but it's just a bigger ask.
We might have time for one really brief question.
What's the possibility, do you think, of trying to do material support type statute? It's not a criminal prosecution against the ideology, but to stop flow of funds?
I think the problem with criminalizing material support to these organizations is designating the organization in the first place. How do we decide which organizations are illegal while not abridging constitutional rights? And I think if you go back to the Claiborne case, right, that shows how difficult it is to really designate an organization as a domestic terrorism group. And so I think that's where, if we were able to do that, I think the material support would be a natural follow-on, as we've seen with the foreign terrorist organization designation. But I think just the concept of designating an organization as a domestic terrorist group is such a hurdle that it's not really a viable way to combat the threat of domestic terrorism.
Well, thank you very much, Melissa.